Good afternoon. We are going to convene the 17th meeting of the Civilian Police Review Board. Happy New Year to each and every one of you. It's good to see you. Thank you for being here. We have excused absences today of Board Member Strickland and Board Member Fluharty. I think I need to provide a little explanation. You can see on your agenda that Gambit Aragon is still listed as a board member, and as I understand it from council, that is the way it needs to be until certain things happen. So I can share with you that since our last meeting, that the mayor did send correspondence to Mr. Aragon. He has until, I believe, January the 20th to appeal the mayor's decision to remove him from the board. If he chooses to appeal, that appeal will be heard by Columbus City Council. And speaking with council, it is unlikely that that could occur at their, I think it would be their February 1st meeting, if I'm calculating this correctly. So that's why the name remains, because technically he is still a member of the board. I did hear that in terms of the meeting invite for today, he declined. So just a little bit of an explanation there. Could I move on to the first bit of business? We actually have minutes from 2 meetings in December. And I think what I would like to do is to handle them separately. So the first minutes would have been from December 6th. Could I have a motion to approve? There's a motion and a second. Any questions or concerns? Then all in favor of approval of those minutes, please raise your hand. They are approved. Then the minutes from the special meeting of December the 19th. Could I get a motion to approve? So moved, second, and a second from Pastor Nathan. Any questions, concerns, additions? Then all in favor of approval, please raise your hand. They are approved. The item number 2, 2-year appointments, and this is just, we'll talk about this more at the February meeting. For those of us who have 2-year appointments, and I think there are 5 or 6 of us, I didn't bring the list today. Our terms will end April 30th. I did go back to verify that. And so what I will share with you in April is what steps you need to take as it is connected to the mayor and communicating with the mayor's office. Essentially, do you want another term, or are you going to say, thank you for the opportunity, but that's it, for me. So we'll go into that a little bit more. It's my understanding, and I have the contact information, that the mayor now has a staff member that is referred to as in-house counsel, Rena Shank. Some of you may remember her from coming before us before. Or actually, yes. But I will be in communication with her to get the specifics of what needs to be done, and we will cover that at the February meeting. I was going to put this at the end, but I want to make sure that we get this done. We heard from Mr. Tobias that we anticipate that City Council will pass legislation that will permit alternative meetings such as Zoom meetings. That has not happened, as I understand it.
Your word choice concerns me. I don't think there was ever any plan to pass legislation. I believe when there was the Charter Review Commission was doing its work, and because of our, and when I say our, I mean Laura and my experience with COVID and helping Columbus Public Health navigate through that, as well as all the other boards and commissions, we thought it might be a good idea to explore the virtual meeting option in a time when a public emergency was not declared. And so I think through that Charter Commission work, that's what you see now as the amendment that was passed and incorporated into the charter. So I don't think that City Council, I may be wrong, but as far as I know, I don't think City Council has any immediate plans. Nobody's drafting legislation right now.
Well, we don't plan on drafting any language, but we do want to encourage them, which I think is permitted.
Absolutely.
So I believe our vice chair has language in a motion that she would like to bring before this board and for us to act upon it if we choose to. Okay?
Yep. And I mentioned this briefly when Laura Baker Morse was here last time about issue 21, which would allow the city to hold meetings virtually in limited circumstances as determined by an ordinance of City Council. So I'd like to put a motion before the board that we ask City Council to pass an ordinance that would allow our committees and subcommittees, including but not limited to review committees and ad hoc committees, to meet virtually via teleconference, video conference, or other similar technology when virtual meetings would allow for the timely consideration of board matters and when in-person meetings are not feasible and/or would cause undue delay in the determination of board business. Virtual meetings must adhere to public meeting notice requirements, including the timing and publication for those meetings to the public. So that's what I would like to propose. I don't know if there's other language, Mr. Tobias, that would be necessary to put in front of City Council.
No, I think that that's appropriate. I think the thing that you said at the very end is probably the most important, that you're not asking for them not to be public meetings, just that they be virtual. So as long as there's notice to the public, and if the public wants to log in and watch the meetings as well. I would say, they should have an opportunity to participate as well if they want to. I know we've talked about the speaker slips or the 3 minutes per person. So that's the advice we've given all the other boards and commissions during COVID, is when you're having these public meetings virtually, make sure that they can see and hear what's going on and they have a means by which to participate.
I do have a concern about a phrase that's in the motion. When it says not feasible, and I'm not really sure what that means, because I think I definitely heard from the review committees, which are beginning to meet on a very regular basis, that this might be a preferred way that they would actually want to meet. And so I don't know if it's a matter of feasibility, other than that's how we would like to conduct our business. And would that be okay? Do we need the not feasible
I
language?
don't think there's any requirement for there to be any kind of an emergency or feasibility. You could just say for the efficient and timely work, the work to be done efficiently and timely. Yeah, and you could speak to the volume of cases and things of that nature.
Would you consider, because actually there isn't a motion on the floor now, you read us the proposed language, but it wasn't actually moved. Would you consider changing the language and bringing it forth to the board as a motion from yourself?
Sure, sure. And if, for purpose of the minutes, thank you. I had it here, but it's larger here. So for purposes of the minutes, I would be willing to strike are not feasible, because then it would just read meetings would cause undue delay in the determination of board business. Because my thought was the number of cases that we're looking at and then trying to coordinate the schedules of all of us who are already coming here to meet monthly in person, and then trying to add other meetings on top of our subcommittees, that it would allow for timely.
And let me just share, and again, it's a caution to the committees. And I think it goes to what you're saying. So we must give public notice, right? And the notice, as I understand it, different from the notice about the special meeting we had, that notice goes out once a week on either Friday or Saturdays. On Saturdays for like going into the future. So we had a case where there wasn't public notice, quite frankly, coming from the committee. And we absolutely must make sure that we are following, that rule. And we also need to make sure that the committees meet in time for what I call the administrative part of the work to be done. So you not only review the investigations, you complete your sheets, you get them back to our executive assistant so that she has them and can then get them to me. And there were just some times this last time around when it was very close. And I do realize that you didn't receive them, I don't think, until, I think the second step was the 19th. But we need to make very, very sure that we are following all of those rules, or from the 6th, from the 6th. So again, it's just another reminder that the chairs of these committees need to make sure that that communication is, that the meetings are scheduled in such a way that we are meeting all of the rules of notice specifically. Okay? And if you have any questions about that, I think the best thing to do is, in fact, to reach out to Ms. Dickus, our executive assistant, on that. She is available to you. Okay? Now back to your motion.
Yes. Okay, so I will formally move that we ask City Council to pass an ordinance allowing our board committees and subcommittees, including but not limited to review committees and ad hoc committees, to meet virtually via teleconference, video conference, or other similar technology when virtual meetings would allow for the timely consideration of board matters and when in-person meetings would cause undue delay to the determination of board business.
Question,
Yes.
and I have to bring this up. So we're talking about subcommittees. They have to give notice, and it has to be open to the public. Am I correct? Because it's I'm thinking about where we were meeting. How in the world is that going to be public if someone wants to come in? 'Cause we were sitting there in our group, isolated, at a coffee house.
Well, all of that has to be taken into consideration. So for example, at the last meeting, I just made a recommendation. Your committees, you don't have to follow it. I just mentioned that recently I've been in a couple of our new libraries.
Okay.
And they have parking. They have nice size, meeting rooms. But all of those kinds of things you have to think about and then plan your meetings accordingly.
I just wanted to make sure I brought that up.
Absolutely.
Madam Chair, so that we can all have an understanding that it has to be in a place
Right.
where we can make it public.
So I think from the first set was done, there was at least one committee that I think actually met in a member's home. So all of those things you must consider and plan accordingly.
All right.
So thank you for bringing that up, but
Yes, ma'am.
absolutely. But I believe that we have enough opportunities, and I don't know, before I say this, if, for example, conference rooms, maybe next door, again, it needs some planning, but I think that there's enough public space.
I've got a whole church I could host a meeting, and so, but I just
Yeah.
wanted to bring that out so that we all have an understanding.
Okay.
About where we should meet and where we shouldn't meet because of the public aspect.
Okay. There's been a motion and a second. Any other questions or comments? Then all in favor of the motion, please raise your hand. Passes unanimously. Thank you. I think, so it is now time for us to begin our review of DIG investigations. This has been a long time coming. And I think I had said that what I was going to do was to do this back and forth thing, rather than having one committee just go through. I think it probably works better if we just have a committee, and we'll do the ones from November 1st. And so we would start with Team 1, Pastor Nathan. And I did have a call from Mr. McIntosh. And let me just say this. We didn't prescribe exactly how you have to present. So, for example, the question that came up was that you need to read the entire, summary or everything that's in the investigation. Do what you plan on doing today, but I think it's probably best if you could just highlight what's actually in an investigation, that you don't have to read the entire thing and then take it from there. Oh, and one other minor thing, but I noticed it today. On your review sheets, It says on that last page, it gives a date return to Inspector General. That needs to be changed. And again, because I'm always concerned about what the public sees, these don't go back to the Inspector General. I mean, they really stay with us. Yes, they're going to our support staff who is housed in the Inspector General, but if someone read that, it might almost give the impression that somehow you review and then it goes back to the Inspector General, who knows what might be happening. And again, my thing is, could that be considered, an ongoing investigation? So we just need to change that. I spoke with Bethany, but
They submitted to chair?
yes.
Just a couple of clarifying questions. Should we be sharing the complainant's name and the officers' names in this hearing, or no?
It's a public record.
Oh, all right.
It is, I mean, it became a public, yeah, it's a public record, so I would say
I
yes.
assume that, but I didn't know. All right. Well, the way I'd like to share is to simply focus on the case or cases where we might have disagreed with the Inspector General's findings rather than running through every single case. So in the November case.
We need to vote on each and every one, though.
All right. Well,
I mean, however you want to lay them out.
we can vote on all of them, but the only one that we disagreed with the findings on in the November cases was 0026. The complainant was Keisha Campbell, and the officer involved was Wesley Tripp and Ethan Rivera. The complainant was in an argument with her adult children, 2 adult children, and she locked the 2 adult children out of her home. The son was living with her. The daughter that she locked out was occasionally living in the home. The police came because of this dispute as they were trying to get into the home, and Officer Tripp, I'm sorry, both Officer Tripp and Rivera advised the son that if it was his house, he would break in. And in addition, that he would kick in a window or throw a football through the window if he had to get in. The mother finally let the children in the house without having the window broken or the door kicked in. The adult children were in the house when the officers left, and the son proceeded to break up all of his mother's stuff, smashed up her belongings. In this case, the Inspector General said that there was not a breach of policy and that the officer was exonerated because the children had a right to be in the house. We disagreed with the finding, and the particular rule that we would cite is Columbus City Rule 8, which specifically offers this language. Per Columbus Central Work Rule 8, failure of good behavior, all employees are expected at all times to exercise common sense, and we focused on that, and conduct themselves in an appropriate professional manner. We felt that the officer did not exercise common sense. He didn't act as a reasonable person in the counsel that he gave to the son and daughter, and in fact, he poured gasoline on the fire. They were already tempers flaring, and instead of remaining there and ensuring that the situation was calmed down, or even assisting the folks to get their belongings and leave, the officers overheated the situation and then left this mother to deal with her adult children by herself, and with the predictable results that her stuff was broken up and a lot of property was damaged. So we believe that this was a violation of the work rule, and that we're recommending appropriate discipline and training for these two officers. And then all of the rest of the cases, we agreed with the Inspector
Well,
General's.
let's stay with that one.
Okay.
For a moment, okay? I would entertain questions or comments from other board members, or even from the other two members of the review team, if you wanted to add anything. But again, questions from other members of the board.
I have no additional comment. I think Pastor Nathan did a good job of summarizing our sentiments with that particular case.
How about, what was her specific complaint?
Her
Specific complaint? What
Her
was she-
specific complaint was a complaint of misconduct, but that the officer's advice to her son, that if anyone locked me out of my house, I'd be getting in, and then under that, a specific series of how they would get in, that this was, misconduct. So it was just inappropriate counsel, and, she didn't obviously know the Columbus City work rule, but that's what we're considering violated.
So my question becomes, now, what you are saying is that that's the advice that the officers gave? That,
Yep.
Okay, all right, I just want to
And
make
it's
sure.
on the body cam.
Okay.
The Inspector General's reason for,
The Inspector General's reason for exoneration was, let me make sure that I get this, that CPD policies and procedures do not require the officers to evict the children, because one of them lived there and the other was living there on a part-time basis. So because they didn't have a policy they weren't required to evict them, they just left them to themselves, which would have been all right had he not gone ahead and offered what we considered to be really unreasonable counsel. That was, he didn't exercise common sense. That's what we're saying.
And I would just add, one of the things that we discovered while looking at reports is that sometimes a citizen would make a complaint, and they would complain about one specific thing. But during the course of the investigation, if something else is violated, simply because, well, it was our opinion, simply because the citizen didn't know that was a rule, doesn't mean that the IG cannot find a violation of some other policy that should apply to, or does apply to, the performance of the law enforcement. So here, even though the citizen's complaint was this very specific thing, he didn't evict them, well, they don't have to. The work rule about, I forget how the phrasing in it, of City Rule 8 should be something that would, at least from a training perspective, younger officers may need to realize that those words carry weight. And so if this officer just needs additional training or something like that, we can't or shouldn't penalize the person who's writing the complaint for not knowing that that's really the rule they should have cited as being violated instead of the one they did.
And I would also add that that work rule was not referenced in the report, so I am not sure if the investigator actually explored that work rule as they were conducting their investigation. And that was one of the premises of a question that we had raised during the last meeting, is whether or not if we were aware of another policy or something that was related. However, it was the IG or the investigator did not bring that up. Could we either ask a question or raise that? And the answer was yes in the last. And so that's what led to that.
So, Pastor Nathan, it's my understanding from those cases that you reviewed from November, this is the only one
Yes.
where your conclusion is different than
Exactly.
the IG's. So I think in terms of handling this, there probably should be a motion for me just on this case, and with, again, I don't want you to restate it, but maybe briefly restate the reason why, and then let us vote on this one separately. We'll vote on all of them separately, but this is going to be a different one.
Right. And so the reason we're disagreeing with the Inspector General's recommendation was that,
Well, just put
I'm
it in the
sorry.
form of a motion.
oh, I'm
In terms of what you want
moving
us as a board to do.
I'm moving to recommend that these two officers receive additional training regarding counsel that they're giving to citizens in the case of a family dispute.
I wasn't going to second, I actually have a question.
Okay.
So would that be the motion, or would the motion be to submit it back to the IG's office for further investigation pertaining to that particular work rule?
And then I have a question, and I'm not sure if you can tell. This gets into the 90 days. And I don't know, I think I've asked going forward that on the IG reports, that it is noted how many days might be left for an investigation. But these were done before I made that request. And so, but you could probably tell that by looking at what you received,
Yep.
which I'm sure I have somewhere in front of me, but
Well, the incident took place on July 14th. The complaint was made on July 18th. And the findings, the memo was October 10th. I don't know what is the tripwire date for the running of the 90 days.
yes. Could you speak up, please?
Oh, I'm sorry. Just wanted to know, in the report, up under the recommendations, even though we did a recommendation of exonerating the officers, we do have an additional part in there where we recommended additional training for those officers regarding their communication with the public to possibly prevent a similar incident from happening. So that is in the report that we did recommend that.
But I believe our recommendation is not the exoneration piece of it,
Right.
though. So that's where I think we may differ.
Right. So
That's
just,
why- I'm sorry, that's why I raised the question as to the specific complaint. Was she complaining because she couldn't evict him and the officer said those things? Or was she simply complaining about what he said, what the officer said to the son?
I'm not sure what the relevance is.
Because you can't evict a person that already lives there. So that was correct.
Precisely, but she was also complaining about what the officer said.
It was about what the officer said.
Just what the officer said, or the eviction too?
It's what the officer said.
Okay, if it was just what the officer said, I get it.
Yeah.
But if the complaint was also the eviction, that's where the exoneration was. And then you have the,
Yeah, well, this wasn't a two-count charge. And for the exoneration was just simply, the officer is exonerated. It wasn't on this count, he was exonerated, and on the second count, where he was not exonerated or we're recommending additional training, what we're saying is he should not have been exonerated, and because he violated a Columbus work rule.
If maybe we can amend the motion then, instead
Yes.
of for further investigation, instead to bifurcate the finding, to find exonerated specifically on the policy about eviction, but then to sustain a finding that the work rule is violated, or at least what was violated that prompted the IG to write training is necessary, but not to couple an exoneration with, and also go get training, if that makes sense.
I have a question as well, because somewhere, I know when we read these reports, it seems like we're, just like the rule that you guys brought up, the work rule. How are we getting tripped up between officers not violating CPD policy and being exonerated, but yet they break a work rule? Is not the work rule part of the policy? I'm trying to understand this. Do we have separate things here?
That's that was my understanding precisely. We
So-
have Columbus work rules, you can speak to that I think apply to all city employees, and then we have police rules that apply to just the police department. Is that correct?
So then it becomes important then that our investigators do not base all their findings on just CPD policies, that they also look at work rules as well in certain situations.
Correct.
And I think that's important, that we bring that up, because apparently our investigators are not aware.
No, they were aware. They cited the rule, but they just, for some reason,
They cited Work Rule 8.
Yeah,
It's in a footnote.
it's in a footnote,
It's in the body of the report.
yeah.
And Madam Chair,
Yes.
if I may, it's helpful to understand what the allegation is, and that will help the board understanding when the investigations are completed. We look at the allegation, and they're either exonerated or not exonerated based on the allegation. However, if the investigation finds additional findings, which we do, that is also added in the report to state what the additional finding could possibly be. In this case, we did recommend additional training. What I would like to do, if it's helpful, is I'll read what the allegation is to know exactly what we look at. We look at everything, but the allegation itself is usually what the finding will be on, because that's specifically.
But am I not correct is that you start with the allegation, but as you investigate, if you find other things, it becomes a part of the entire case,
Absolutely.
right? And that's all I think that has happened here.
Absolutely, absolutely. So what I just wanted the board to understand, so if you're getting hung up on what the exoneration part is, that we're looking at exactly what the allegation was. The additional findings in the report will list that. So again, to what your point, if you're saying that the work rule, and we do talk about work rule 8 in the investigation, if you're stating that you felt that the officers' actions violated the work rule, and so you disagree with us exonerating that, that would be the part that you would say, we disagree. We felt that the officers did. And so that part of the investigation we could change. We wouldn't necessarily need to reinvestigate something that we've already presented the finding.
We're not recommending that you reinvestigate.
Oh, okay.
That's why I moved to modify the language, just to clarify that instead of sending it back for more work,
So
just fixing.
A motion isn't actually on the floor. We were just kind of talking about it. We hadn't actually gotten to a motion. So would you please make the motion that we can act on to resolve this matter?
Yes. Could someone read me the case number again, just so I say?
0026.
0026, okay. We move that report 0026 from the IG, instead of reading exonerated with additional training recommended, instead we would like to specifically see it read exonerated as to the allegation pertaining to eviction, but sustained as to violating City Work Rule 8 with the recommendation that already exists in the report for training.
You have a question for the second counsel.
Well, I mean, I think I'm just going to try to simplify it a little bit for you. I don't think that the final conclusion from the IG and the report has to gel with whatever your conclusion is, and it doesn't have to be modified or amended to reflect that you disagree. Ultimately, in advance of the meeting today, I looked at the charter and the applicable code sections in terms of what the role of the board is. And it's to make recommendations on resolutions of the complaints and if warranted, to recommend discipline. So you can, in the motion, you can just say, we agree with the IG's findings in relation to the exoneration for eviction. We disagree with the IG's findings related to a violation of Central Work Rule 8, and we're going to move to recommend training. And that's it. That's all you need to do. Because you don't need to send it back to the IG.
No, we're not going to send it back.
The goal here is not to have everything gel together at the end on the ones that you disagree with. It's okay to disagree. You have final authority to recommend whatever you want. So you just simplify it and say, the motion is to sustain or agree with the finding related to the exoneration on the eviction, disagree on the finding related to the criminal work rule 8, and to recommend to either the chief of police or the director of public safety the following.
Perfect. I will restate that. I move that the board on report number 0026 agree with the recommendation from the IG of exoneration on the issue regarding eviction, but that we disagree as it relates to Work Rule 8, and we recommend additional training for the officers involved.
There's a second. Any further questions, concerns? Then let's,
Decide who the recommendation is going to go to. It can go to either the chief of police, it says, I think it says and/or.
and for all motions, if and I'm not going to ask us to approve this, your chair would prefer that, at least initially, that we send all of these to the police chief. And so if you can make that a part of your motion, I would appreciate that. But it goes to the police chief.
Motion so amended.
Second.
Now, ready for a vote? All in favor of the motion, please raise your hand. Approved. That was, I should have put it, I won't say monumental, but I mean, that's the first in terms of our business after almost 2 years in terms of reviewing these. So I would just take a moment and say thank you. Pastor Nathan, the rest of your cases.
The rest of the cases, I don't know if I need to move on each one,
Well, let me ask,
or if I can do them, and read them off and move on all of them.
I think I'd like to hear from the board members who, am I going to hear from our lawyer first?
I just feel like sitting towards the front of my seat is probably a better idea for the rest of the meeting.
Because I do think, again, the reviewing committee, I mean, you've done your job.
Yes.
But I do believe that board members should have hear a little bit more about what the investigation was actually about before we vote on it, rather than just accepting your recommendations to us without really any, I don't want to say review, but any potential input. So that's why last meeting, when people were saying this could be done, or maybe it was December 10 minutes, I had a tough time believing that, because I think it's our responsibility as the full board to receive your reports and then to vote on them.
I would say if there's a group where you're agreeing with the IG's report of exoneration down the road, you can do those in a group. But for the ones where the recommendation is for training or discipline, then there's specific training or specific discipline for each particular complaint. You may not be able to do those in a group.
So I think yes.
What if we have a question? We agree with the IG, but we just have a question about their investigation. Do we ask it here? How is that handled?
Well, I mean, if you think it may change your decision, then you should ask it here. But I mean, if it's just more of a question about process or paperwork or administrative type things, you can always ask it at some other time, not necessarily during this open meeting.
How about if we want to make a recommendation
regarding,
regarding police procedure?
right, I mean, there's also an opportunity for the board to make recommendations to the police regarding policies and protocols. That can be done separate and distinct from the actual investigations, or you can make it part of your recommendation related to any individual complaint.
So I'm going to ask you to hold your question
Okay.
until we maybe get there, because
Okay.
I'm still
Okay.
a little concerned. So there are probably, I'm not sure how many more cases you have from November, Pastor
I
Nathan.
think 9, and that we agreed with the Inspector General on all of them. On the rest,
And they were
but I
all
can-
exonerations?
no? No, I can share, I can do whatever you'd like.
Yes, I think we need to hear just a little bit about each case and your recommendation. This is our first time doing this. We may change as we go along, but I'm just uncomfortable.
Sure.
Just accepting your conclusions without hearing
Okay,
anything about these matters.
great.
Okay?
Suggestion, on all of the reports, I know in the beginning we did a summary. That might help you if you're presenting that to the group to just kind of do the summary, because the summary tells a little bit about what the allegation is, and it summarizes what the finding is. That might,
Yep. All right. Would you like me to start?
Yes, please.
All right. Well, we have case 0003. The complainant alleged excessive use of force, but the body cam in this particular case with Officer Metz disclosed the use of profanity, and the IG recommended disciplinary action due to the use of profanity by Officer Metz, which was a violation of police policy, and we agreed.
Any discussion, questions? So again, and if my lawyers or lawyer here is thinking that I'm being too formal with this, let me know. But I'm still thinking this is, again, this is a public forum. In a way, it's a public record, that there should be a motion and a second to, well, depending on what the motion is, but basically to accept the recommendation of the IG. Okay. So I need a
So
motion.
we're moving to accept the recommendation of the IG in case number 0003.
Second. Any further questions or concerns? All in favor of the motion, raise your hand. Pastor? Raise your hand.
Oh, I'm sorry.
Motion passes.
All right, case number 0029, the complaint is classified as misconduct. There was a failure to take an accident report, and the finding was that the officer in this case did violate CPD policy by failing to take an accident report, and so they sustained the findings, and we agreed.
And I'm sorry, what case number was that?
0029.
Any questions from board members? Then a motion?
I move that the Inspector General's findings on 0029 be accepted.
Second? Second. All in favor, please raise your hand. Motion
I
passes.
did. Okay.
Jackson?
Yes,
These IG reports also suggest that the additional training or discipline? Okay, if the board wants to recommend any training or discipline above and beyond what's in the IG's report, that's within
what I
your
was-
authority to do that as well.
okay, thank you.
I just have a quick question.
Yes.
Pastor Nathan, are you reading the summary paragraph
No.
in the, okay.
No, I'm
Just you guys-
summarizing the summary.
Okay, so that is
So that we
different
could
from
get out
the
of here today.
suggestion from the IG. I just wanted to make clear, that is not the actual summary. I think the summary has a little bit more detail, so it's up to you,
And I'm
Chair.
not, I said earlier, that we didn't necessarily need all of the detail, that board members should just pick the words, but it was not necessary to do that. And I, so far, not being a part of this reviewing committee, I am comfortable with what Pastor Nathan is doing at this point.
Perfect.
So we have case number 0051. The allegation was misconduct for a failure to take an accident report. But in this particular instance, given the facts of the accident, there wasn't a requirement for Columbus Police Policies to require a report. Therefore, the officer was exonerated, and we agreed. So I'm moving to have case number, our agreement with 0051, the Inspector General's exoneration, be approved.
Any further questions, concerns? All in favor of the motion, please raise your hand. Motion passes.
Let's see here. Got a lot of paper. We have if one of you want to pick up the the slack here.
Yeah, I don't.
Oh, we have case number 0054. This one involves the allegation that the complainant was assaulted by 4 teenagers and that the officer in this case failed to investigate. The complaint was not sustained by the police footage, and so the officer was found to be in compliance with CPD policies, and her complaints were alleged to be, were found to be, were unfounded, and we agreed with the exoneration of the officer in this case regarding this particular allegation. So I'm moving that in case number 0054, the IG's recommendation of exoneration be accepted.
Second.
Any further questions or concerns? All in favor of the motion, please raise your hand.
All right, so where am I here? We have 5-4. We did 2-6. We did 03, 29, 51, 54. Okay, 59. Let me find that one. In this case, there was in case number 0059, there was an allegation that the officer issued a false traffic citation, which was a failure to yield because he was too busy watching YouTube shorts about cartoons and semi-naked women. And that as a result, he could not have observed the alleged traffic violation because he was watching these YouTube videos. The IG found that the complaint against the officers, these 2 officers, be closed with a finding of unfounded. After looking at the evidence, we thought the IG investigated fully, and we agreed there was no evidence that substantiated the allegations that they were watching YouTube shorts and cartoons. So I'm moving in case number 0059 to accept the IG's recommendation of exoneration.
Second.
Questions, concerns? All in favor of the motion, please raise your hand. Motion passes.
We have case number, let's see, 0004. And in this case, well, I can read it. I don't. The complainant alleged that while sitting in a vehicle, the officer opened a car door, ordered him to leave the bank area. Complainant stated that profanity was used by the officer, and he stated the profanity. In this particular case, the profanity, I think, was backed up by the officer did use profanity and therefore violated rules of conduct from the Columbus Police Division, Directive 1-01, conduct unbecoming of an officer, and Central Rule 8 about not being rude, unprofessional, and using profanity, which is a prohibited act. And therefore, we agreed with the IG's finding that Officer Badger did violate CPD policies and the Columbus Work Rule, and so we're supporting in this one allegation the finding of sustained. And so I'm moving that the IG's finding of sustained regarding the unprofessional conduct of the officer and the use of profanity be accepted.
Second.
You got to list the case number.
In case number 0004.
Questions, concerns? All in favor of the motion?
We've got,
You in favor of the motion, Pastor Nathan?
I am. I thought you were like wanting me to wave a hand for I give up. Then, let's see here. 0153, let me find that. This was a complaint, this is 0153. Complainant alleged that these two officers did nothing when responding to his two calls for service regarding two separate incidents. One of the incidents involved somebody showing up at his residence trying to fight his daughter, and that as she was leaving, somebody pointed a gun. The IG investigated and found that they did not violate CPD policies, procedures, or laws, and that the officers be exonerated. We agreed with the findings based upon the body cam and other evidence, and as a result, I'm moving that the IG's recommendation of exoneration in 0153 be accepted.
Second.
I have a question. I thought.
Yes.
When you started, you said that there were, that the complainant filed 2 complaints.
There were 2 allegations in the complaint.
Oh, okay. I'm sorry. Thank you.
There were 2 calls for service, 2 separate incidents that morning.
There's been a motion which has been seconded. Questions, concerns? All in favor of approving the motion? Motion so approved.
All right. We have case number 066. Let me see if I have that. I think I have different numbers than are on this sheet of, so I can give you the other ones. I don't have, do you have your computer? I don't have 066 in my notes.
I think there was an issue with our first round of reports. A couple of our case numbers didn't match up with what the
Yes.
emailed version was.
Exactly.
So,
So I can give you the ones that I've got, but they don't correspond with this agenda item.
Okay, so there
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 were
isn't-
different numbers. It was, one was a matter number, and then the other was the actual case number. So sometimes with those 2 different numbers, they get mixed up on the cases, if that makes any sense.
So you're indicating that your committee did not have a complaint.
For 0666,
Okay. Do you have one?
66, I'm sorry.
From looking at the agenda, do you have one that has actually 2 numbers combined?
Yes.
0021 and 0019?
Yep.
Okay. Why don't you move forward with that one?
Okay, so let me get that. This is case number, it's got 2 numbers, 0021 and 0019. Complainant alleged that officers arrived at her house, drew their weapons, arrested her at gunpoint, and while she was in handcuffs, one of the officers yanked the handcuffs and told her that next time it will hurt worse, and that during the arrest, the officer called her husband a pillhead. And a review of the body cam found that the officer did at one point ask her to stop moving around so much, but did not say next time it will hurt worse, nor any variation of the statement. And he did not call her husband a pillhead, but her husband did mention that he was intoxicated, and the officer inquired whether he had taken pills. The recommendation by the IG was that all the allegations be closed with a finding of unfounded. I'm moving that we accept the IG's finding of exoneration in this case.
What's the case number?
Well, it's 2 numbers, 0021 and 0019.
I have a question.
Yes, please.
In that particular case, was there a BWC video?
Yes,
Okay, and it did back the officer up?
Precisely.
Okay, all right, I just wanted to know that.
The second. Any further questions? All in favor of the motion? Passes. Before we move further, could I ask the IG from your records, do you have an investigative report that has the number 0066?
Yes,
You do?
yes.
Okay. We'll see where that one. is.
I don't think we received it. At least our committee did not. I don't know if it went to another committee.
Or if there's a file saved with a different number.
Okay. We'll have to look into that. Does that conclude your?
No,
okay,
let's see. Did I do 0002 already?
No.
Okay, so I think that's the last one. Let me find it. Zero, 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 two. This was, in case number 0002, the claim was that the Columbus police officer was on a scene when there was a hit skip that occurred and that the officer didn't complete an accident report. Finding was that unfortunately they could not, I think this was the one that they couldn't identify the identity, the IG was unable to identify the Columbus police officer who was allegedly on the scene during this hit skip. There was no badge number or name given, and so they couldn't determine if an officer on the scene actually saw the hit skip accident, and there was just simply insufficient information to identify the officer, and so we accepted the finding of unfounded in this particular case. There was just simply insufficient information to substantiate the complaint. And so I'm moving that in case number 0002, the IG's recommendation of, I don't know, I guess it would be unfounded, be accepted.
Any questions? All in favor of the motion? Motion passes. Thank you.
You're
Thank
welcome. It's like first year law school.
you. Well, one of the things that I was, thinking today is not only are we volunteers in terms of serving on this board, lack of administrative support, I mean, not in terms of what comes from the IG's office, but just your own personal, in terms of keeping everything organized, I guess would be the word.
Well, and if you weren't prepared to speak about the cases that we agreed on.
So we were prepared to only report out on the ones that we disagreed on. That's what the.
And I'm,
Yeah,
way,
we're
though.
we're fine.
yeah, no,
We're
because
fine.
as I said, I do really believe that we have a responsibility to each other as board members and to the public. And so we will continue with, and as we do that, we might use some highlighters for keywords and some other things as we go forward. But I really do believe that is our responsibility. And if that wasn't clear, then that's on me, and I thank you.
Madam Chair, as you can see, one of your committees and a few of us, we do have highlighted letters.
I unfortunately just underlined with a pen.
It makes a difference. It makes a difference. Let's move on to the review team, the that is chaired by Kyle Strickland, but Board Member Mary Younger is going to report out today. So this would be, again, the cases that were assigned in November.
Correct. I'd like to start by clarifying the numbers. They're not exactly correct on the sheet. Do you want me to give the correct numbers? The sheet on the agenda that we have here?
Okay.
It's 005, and then there's 006, and then 008, 0010, 0011, 0035. There is not a 0041 nor a 0045. There is a 0088, 0097, 0098, and 0163 for a total of 10 cases. Okay?
Okay.
All right, I'll begin with number
Well,
one.
just,
Oh.
if you would just take a look for me, you don't have to respond right now, the two that this committee does not have, 0041 and 0045, and I'll come back to that when she finishes. Please proceed.
Correct. The first one is DIG complaint number 2022-0005. The type of complaint is misconduct. There is one allegation. The complaint alleged the CPD failed to properly respond to investigate shots fired. The findings here were the allegation against both officers. There were two officers involved were exonerated. Basically, very quickly, the facts are that the complainant stated that she heard 18 shots, waved down a cruiser. Officer did not slow down, speak to her. The investigation revealed the two officers on the scene, one had a body cam, one did not. One body cam was, footage for one body cam was reviewed. The IG also reviewed a 911 call. They reviewed the CAD reports. They reviewed all the pertinent standard operation manuals regarding this. The time from the call to the end of the total call was 4 minutes. We thought about this a little bit, and then putting everything together, we thought you could do it in 4 minutes if the officers got there, talked to one of the neighbors, and went through the alley, saw that nothing was going on, and after reviewing everything that the IG did, we agreed with the finding of the IG here. So since everything was fine, we move to that the findings of the IG be accepted. In case number. Oh, in case number, thank you. 2022-0005.
Is there a second? Second. Any questions, concerns? All in favor of the motion? Motion passes.
Number two, DIG complaint number 2022-0006. The type of complaint is misconduct / unbecoming conduct. The allegation is that Officer Davis failed to properly respond to a 911 call, report of a DV. The finding was that Officer Davis is exonerated. In this case, the IG went through CAD reports, the BWC of Officer Davis, medics examined the complainant, and Officer Davis also spoke with her. In this case, the complaining witness called the police on a DV call. She was intoxicated, would not let her boyfriend take the kids. Children's Services became involved in this situation here. Just a little bit more about the facts. It was a DV situation where she was living with her boyfriend at one residence, and she was asked to leave, and the officer here tried very hard to explain to her that he would have to call Children's Services if she didn't give permission to let them stay with the boyfriend. The officer spoke with her quite a bit, and she was nonsensical with the officer, stating things like, I'm buzzed, I'm just things that just did not make sense. And a review of the CAD report and the BWC footage by the IG indicated that this particular officer here at this time needed to be exonerated. We agree with this situation. So at this time, we move that the findings of the IG be accepted.
And what is the case number
Oh,
again?
I need to, 2022-0006.
And I would just, well, let me finish with the motion first. There was a motion, and then, was there a second?
Second.
Second. Questions, concerns? All in favor?
I'd remind board member Younger to raise your hand if you want to
Oh,
vote
I'm
in the
sorry.
affirmative.
Yeah.
You have to be my eyes. And we all, though, even though you're making the motion, we do need to vote.
Okay.
Okay.
I'll remember.
So that motion passes, and I would just say, and this would be administrative, as I look at the agenda for this team, I don't see a case 0006.
It wasn't on here. I read it. When I read it, I read it.
Okay, so just a
Yeah.
note, and we'll have to do some double checking on these, okay?
And also, just a quick question. The Inspector General did not sign our copy. Is that just because we got
If
to?
we have it, her signature should be on it. I mean, they're only coming in once.
Okay,
So-
so on this particular recommendation, the signature is not on here.
Now, for which case is that?
It's 0006.
Yeah, my signature is on my copy, so I'm not sure. So we'll just have to check to see why not, because the copy I'm looking at has my signature on there. So we'll just
right.
have to check and see what happened with that.
Okay. Okay, ours didn't happen, but I just wanted to double check. All right, our next is DIG complaint number 2022-0008. This is misconduct and excessive use of force, and it also involves Officer Davis. This one is a little convoluted. It's number one, the first allegation is illegal search, and the second is unnecessary force on Mr. on the complainant. The individual who called here was the mother of Mr. Bridges, and Miss Bridges called the IG, and she indicated that she got her information from her son, and she explained that her son was stopped by the police and that he, let's see, there's a very briefly here, and that his fanny pack was searched illegally, and that he also was tased and fell to the ground and fell on concrete and suffered a lot of injuries because of that tasing. The IG reviewed the U-10 report, the arrest report. They reviewed give me just 1 second here. They reviewed the body cam for Officer Davis. There were 2 officers involved. The body cam for also the second officer there, and the use of force reports, and then all of the, there was also a chain of command letter, use of force, because the sergeant was also there. And the findings here were exonerated by the officer. The problem here, the arrest report indicated that the officer witnessed what he identified as a hand-to-hand transaction between Mr. Bridges and someone else. And he indicated that he thought that what was going on here was a narcotics deal where Mr. Bridges was the seller. And so at this particular time, this would give him a reason to stop and question Mr. Bridges. So he asked him, he stopped him, and then he asked him if he could search his fanny pack. Mr. Bridges ran. So at this point, he used his taser, and causing him to fall to the ground on concrete, and he suffered lacerations, he suffered possible head injury, and there were a lot of, let's see, the medics were eventually called, but Mr. Bridges did not want to go to the hospital with the medics, so they took him to the hospital, and he eventually was summoned to court. So our group had a question for the IG in this particular case, because there were two officers involved, and the taser, excuse me, they were close enough to use the taser, and so our question is, what is reasonable force, and if he was close enough to use the taser, why did they tase him on concrete and that close? Couldn't they have just apprehended him rather than cause all those injuries? That was we needed to know the reasonableness of the force. How did the investigator make that decision? I mean, we see what the IG did.
What was the recommendation from the IG, or the conclusion? I'm not sure I've heard that.
Oh, the finding was exonerated.
Oh, okay.
For Officer Davis. So the policy on lasers, tasers, I keep saying, thank you. We see that the police directive number 204 says that they're allowed to use it for a fleeing subject. However, it also says that you should take into account the individual and where you're using it. And they used it on concrete when both of them were close enough that maybe they could have found an alternative to the taser. And so that's one issue. The only other issue we had was we saw that the investigator had made many opportunities to speak with Mr. Bridges, the individual who was tased, rather than his mother, who made the complaint. And we thought it would have been a good, maybe more attempts to speak with him would have been important here to get from him exactly what happened here.
Let me ask a procedural question. So the committee received, the reviewing committee received the report.
Yes.
You've reviewed it. Did you come to a conclusion? Or are you bringing this back for further investigation? I mean, what did you do?
Yes, we reviewed it. We, and you can help me out here. We see what the officers did, but what, all right, this is 8. And I'm looking also at Mr. Strickland's we have some questions, like what does, because the committee, the IG did not found that this was reasonable. What is reasonable use of force? We thought that maybe with an answer of a question, we could deal with this here, but we didn't know exactly what the procedure was going to be. Do we get our questions answered here by the IG and then we can just move on? And so how did the investigator determine what is reasonable use of force here? And that's what our question is.
So you
because-
didn't come to a conclusion?
Well,
No. So I think, and this could have been at the November meeting, and I don't know if it actually made it into the minutes. I don't know if it was when we were getting training, and so please, if someone else can have specific recall. I think we discussed whether or not it was appropriate that if during the committee's review of cases, if a question came up, did it just make more sense to reach out to the IG's office to get that question answered rather than bringing it, here or referring it back? Ms. Ross, you seem to be agreeing with me.
Agreed, because as all of you know, these are case-by-case situations, and so there may be, we may need to refer back to the case, refer back to the transcript for the interview, the recording for the interview. I think it would be unwise to try to give an on-the-spot response to a question like that, but if you can provide it prior to the board meeting, then we can have a prepared answer for you.
The context of that conversation that you were just talking about, we did say, and the IG did agree to accept questions prior to. As a matter of fact, I believe she said that was her preference, so that way, if there was anything that she can help clarify before that information is reported to the board. But you then came in and expressed that we should be judicious in doing that, so we're just not randomly asking her any old kind of question.
and the question should come from the chair of the committee.
Of the
Of the
committee.
subcommittee.
Yes, of the
Correct.
subcommittee. Yes.
Madam Chair, although we had these questions, if my memory is correct, in the midst of dealing with this particular case, because I remember it, I know I came to a conclusion, and I believe that we did come to a conclusion to agree with the IG, but with the questions.
Right.
But with the questions, see if we can have those questions, answered.
So if we,
I'm sorry.
so I'm still
Exonerated.
confused. If you came to a conclusion, so that you came to the conclusion to agree
Yes.
with it, so I'm wondering, as you ask the questions now, is this not so much for this particular case, but potentially a learning experience for us going forward
Yes, ma'am.
with other cases, which means we could ask the IG to look into this, and then at our next meeting, answer the questions that have been raised. And so it would be, again, a learning experience for us.
Exactly.
Would that be acceptable?
Yes,
Yes.
ma'am.
Okay.
Yes.
So is there a motion?
Madam
There
Chair.
is a motion.
Pardon?
Madam Chair,
Yes.
I will probably, if you ask me the question, I will be able to provide some clarity for some of the answers that you have, and maybe that will clear up and we may not have.
Well, if they've come to a conclusion, right, and I'm moving this along, I would like to hear the motion, move on it, and again, use this as a training experience, get something very specific. You may even want to talk to the specific investigator on this and come back, because again, this is a learning experience. And it's my understanding from what I'm hearing is that you don't need that information to move forward with a motion. Am I correct?
No, I mean, we don't. We don't. Because on a couple of these, we just want to say to the IG, take a look at, or to the investigator, take a look at these situations.
And again, a
Down the
learning
road.
experience. And so
Yeah.
I think it's absolutely appropriate coming from the board members as you review these cases. You might again be able to come to a conclusion in a particular case, but you'd like to hear something more from the IG in terms of the thinking and the process, et cetera, that can be helpful both to the IG's staff, but also to us as we move forward with other cases. I mean, I'm not trying to, I'm trying to figure out what the reviewing committee
Well, let me
wants
make
the chair to
some,
do.
You know, if the taser is part of CPD policy, we want to make sure that we have a clear understanding when they are supposed to use the taser. Are there certain circumstances where they should avoid using it, like with the hard concrete and all this other kind of stuff? We just want to get a good understanding going forward.
On the use of a taser.
Yes, ma'am.
So, and I would just, no. I would just, and it was different, I would remind us of our training that has been so many months ago. We had scenario training.
Yeah.
I think this time around, we had 4 scenarios, and we had a choice of weapons, including, the taser. As I sit here, I don't specifically recall during the scenario training having the sergeant say to us, this is when we use, a taser, et cetera. But again, this is the kind of learning experience where it might be appropriate to have some more specific, and I'll use the term training or education, about the use of a taser that could help us going forward. Mr. Tobias, were you trying to say something?
Just add, and there's a use of force continuum that Columbus Police uses, and there's training, and it helps explain where the taser falls in that use of force continuum and when it can be used, and that probably complements additional guidance for the officers in terms of like Chair Member Younger was saying about, or Board Member Younger was saying about the surface or the conditions that are present at the time. It's the totality of the circumstances based on the training. I believe there was training by CPD related to that use of force continuum, but if somebody needs a refresher, there might be a handout or something that can be provided to the board.
Okay, I think that Dr. Jones had her hand up when I interjected, so I'm going to come back to Dr. Jones, then I think Reverend Tatum, and then Pastor Nathan.
So I think I was just going to agree with what you were saying and mention the training that we had at the academy. In addition, we did have a use of force training in the in one of our sessions. And if I remember correctly, that PowerPoint with the actual use of force continuum was passed out to all of the board members. And so the issue, though, that I think I'm seeing here a little bit is that understanding the context of when that taser can be deployed. And there's so many factors that have to be taken into consideration, including the distance of the officer from the individual, perhaps the surface, but also the body size of the person that is going to be tased. And so I was actually wondering, and I don't know if you said it already, but was there body camera footage that was reviewed during this?
yes, there was. Yes, there was.
Okay, and with that body cam footage, the findings was exonerated?
Yes.
Okay.
It just wasn't mentioned. In the report, the body size was not mentioned, but I can see where that would, or how far away.
Yeah, because that also goes
That
and
goes-
determine the impact, whether or not
Right.
the taser is effective. And then I think you had also mentioned something about, exploring alternative methods. And I don't know at that time whether or not, what would that alternative method be? And would that actually help de-escalate or handle or
Right,
control that
right.
situation per se? We don't know.
And that's why our question was, how did the investigator determine that this was reasonable use of force? We just wanted a little bit of clarity to that question, because these are the issues. The things that you were bringing up are the issues that, how far away, how big was the individual? What was the determination that caused that officer to use that particular use of force at that particular time? Should the officer what did the body cam show, and should the officer have been interviewed? Why was the taser used rather than just a lesser force?
I got one more question.
Sure.
If I remember correctly from the use of force training, I don't know if we got some police officers in here, Rock, but aren't they able to use a use of force that is 1 degree higher than the actual situation or something like that?
I'm Commander Allied with the Columbus Division of Police, and thank you, Dr. Jones, for asking the question. If I could interject.
Please.
So the basis behind police officers using force is they have to use force that would be reasonable to a reasonable police officer, based on the circumstances. The circumstances are different for every individual incident. And yes, when we are talking about a use of force continuum, it is reasonable to use one level higher than the level used by the subject. But, once again, I have not reviewed this case. I have not reviewed the specific instances of this particular incident. So, without viewing the evidence and the documentation and the body-worn camera footage, I would just say that as long as the officer is using force that would be reasonable to a reasonable police officer, then it should be exonerated if we're talking about the use of force and whether it's within policy or not. I hope that's
Okay.
helpful.
Thank you.
That's very helpful. Thank
Yes.
you.
Thank you.
I yield.
Okay.
I'm sorry.
Just very quickly, I think that entire engagement outlines the importance of making sure we have a process for how we're going to do people speaking about a particular case at the board meeting. So if those questions can be asked ahead of time, we can maybe say, these are the answers, and if there is an officer that we want to provide input to the board at meetings, we can have that on the agenda. I think that's just going to be important moving forward.
Thank you. So let's be clear that as you review cases, if you have questions, but again, I will, and these are your original cases. So I know that in the second set, you just met like last week, so there maybe wasn't even time to get questions. So again, the timeliness of meetings around reviewing committees, so that you can identify these questions, if any come, for this reviewing committee, there's at least this one, there may be others, and you can then get those questions to the Inspector General, get your answers before we get to the meeting, the board meeting.
And the other piece of guidance that I would give is for the committees who are reviewing these complaints, when they're reviewing the IG reports, is not whether some other lesser use of force should have been used, it's whether the use of force that was used was within policy.
I think that's a very important point, because I think we were really second guessing
Yeah.
here. And I don't think that's where the question should have gone,
Okay.
okay?
All right. Thank you. So at this point, I would move to accept the findings of the Inspector General, and for case number 2022-0008.
Second.
All in favor?
Yes.
Raise your hand.
Oh, yes, thank you.
The motion passes.
Yeah.
Thank you.
Next, complaint number 2022-0001, 0010. And this is a misconduct, and this is Officer Cole
I'm
took...
sorry, what is the case number again? Okay, yes.
The allegation is that Officer Cole took a wallet of a complaining witness at a traffic stop. This was closed administratively. Mr. Hurd stated that his wallet was missing after search of the vehicle. The IG, he later found it at his house, and so it was closed administratively. We all agreed that it should have been closed administratively. I move that the findings to the IG be accepted.
Case number 00.
Case number 0010.
All in favor? Motion passes.
Next, 2022-0011. This is misconduct case, force and profanity. 3 allegations. Officer used excessive force pushing Officer refused to give his badge number. An officer called him a profane name. Findings, excessive force exonerated, unfounded as to allegation number 2, refusal of the badge number, and number 3, not sustained as to the profanity. In this particular situation, the IG reviewed policies, procedures, the videotape from the Kroger store, let's see, yeah, and all the BWC footage. In this particular situation, there was an off-duty police officer working at the Great Southern Kroger. The complainant and one of the Kroger employees got into a little bit of a verbal dispute. The off-duty officer guided the complainant and the employee outside since they were kind of yelling at each other. And let's see. Guided them outside, and then they used the IG reviewed the store camera. There was no the Kroger asked the footage didn't have a speaker. It was just video. So they reviewed that, and it showed that the officer was pretty much just guiding them out. So he did not shove excessively. So allegation number 1 was proper. You could also see that the two of them, that the employee and the complainant were yelling at each other, and the complainant was. Officer Campbell then spoke with him, and Officer Campbell indicated that the complainant made aggressive and vulgar comments to both of them, and he threatened to kick the store managers behind, etc. And so after reviewing all of this, and the three of us agree with the findings of the Inspector General. As to case number 2022-001, I move to accept the findings of the IG.
Any questions?
I have
All
a question.
Yes.
Yes.
But this is going to go back again to what we were talking about in this last case, and maybe somebody can answer this for me. If I remember right, I don't have my sheets because I gave them to Kyle, but I remember this case. If I remember correctly, this particular officer, although he was an off-duty officer, he was an off-duty detective. And because he was a detective, he did not have a BWC on. So now the question becomes, isn't there a policy now where all police officers have to wear BWCs? Are detectives still not required to wear BWCs?
I actually had lunch with the chief recently, and because I had read an article, and as I recall, it is not a blanket, everyone must have a video camera. There are exceptions, and detectives are what, am I correct? It depends on what type of detective?
Now let me pull the policy. It's off-duty versus on-duty. So if you're special duty officers, not all special duty officers have to have BWC. The BWC is reserved for on-duty officers, or at times there may not be BWC available for special duty tasks. Again, we have to refer back to the direct language of the policy, which I think calls out special duty officers versus on-duty officers.
Okay.
Okay, I just wanted to get some clarity.
Okay.
Because I know that was one of the things that was kind of brought up by the investigator, was the fact that, he was a detective and he did not have to, he was not required to wear, body-worn camera. But also, I think it was brought out that if he had one on, then a lot of the other stuff could have been avoided, because it would have been some good footage, because that footage that they had at this particular store was grainy.
Right.
Okay. So, there's a motion,
Yes, ma'am.
seconded, did we vote? I don't think we did. All in favor of the motion? Motion passes.
The next one is DIG complaint number 2022-0035. This is misconduct. Allegation failure to file charges against the aggressor and make an arrest. The finding in this case is exonerated, and in this case, the mother, the complainant was the mother of, she called on behalf of her son. She wanted to have his girlfriend arrested because she struck him, she allegedly struck him in the eye. She did not witness this, but she heard from him that he had been struck in the eye by his girlfriend. This was the allegation by the complainant. The Inspector General viewed the BWC footage for the officer involved, read all the reports, and they found that basically they spoke with the son, who indicated he did not want his girlfriend arrested. The only individual who wanted her arrested was his mother. And there was no physical, nothing physical as far as the evidence was concerned. And he did not want her to go to jail because they had a child, and he was the one that was intoxicated and showing signs of that. And so at this particular time, the conclusion was that they followed, the IG did the full investigation. The officer did everything he was supposed to do. He took the time with the female to check out, make sure that she was okay, make sure that the male was not afraid of the female, even though she allegedly hit him. And there was a recommendation of exoneration, and we agreed with the IG as to case number 2022-0035.
Motion.
We move that, to accept the findings of the IG as to 2022-0035.
Questions? All in favor of the motion? Motion passes.
Wow, there's a lot left. 2022.
I take, since you mentioned that, and it is 10:04, and we usually take a break earlier than this. I was trying to see how far we were going to get. I think it's probably appropriate for us to take a break at this time. I'm showing 3:50. Let's take a 15-minute break, so we'll come back at 4:05.
Actually, there's only four in one of them.
So what we're going to attempt to do between now and 5 is to complete the reports from the November meeting. We will not attempt to go into December. As it was pointed out to me, I think that the committees received fewer cases for December, 8, and I've just looked, I have another 16 to assign today. And one of the things we also are going to do, some conversation, how can we improve this? And I heard some language about developing a template that all the committees might use. And I'm going to turn this way so I'm not looking at her as I voluntold Dr. Jones to help with the creation of such a template, because she's so good at that type of thing. Outstanding. And so we hope to get that done and out, so it'll be helpful before our February meeting. So that's what the goal is. But with that being said, remember, you'll help with that?
No.
Oh.
No, I'm in agreement.
Are we ready?
Okay, yes. DIG complaint number 2022-0088, misconduct, operating of a vehicle, or the allegation was there was misconduct in driving. Findings unfounded, and the allegation was this officer was speeding on I-70, weaving in and out of traffic. The IG reviewed the GPS report, found that the auto was parked with the keys in the ignition at the time of the incident. The finding unfounded. The three of us, the IG, they did everything. We are in total agreement.
And so your motion is?
We move to accept the findings of the IG.
In case number?
In case number 2022-0088.
Second.
Oh,
There's a second. All in favor?
okay. Man.
Motion passes.
Okay. Next, DIG number, complaint number 2022-0097, police misconduct allegation. Driver of vehicle L-5 was speeding without reason. Finding exonerated. The IG reviewed the GPS report, CAD report, audios from one officer, dispatched radio traffic. The complainant indicates that he followed 4 officers who were driving 90 miles per hour because he paced them, and they were weaving in and out of traffic, and then they had no lights or siren, and they eventually went to a restaurant called Me Mexico. And the IG reviewed all of the evidence, and they found that actually the Officer Zachary Scott did.
Your paper's hitting the mic.
Oh, sorry, thank you. Okay. Found that there was a gun run. He was on a gun run, and so he himself was traveling at 93 miles per hour heading towards Freebus Avenue, but when the first unit arrived, he then stopped and went within normal range, and all procedures were followed from then on. The 2 officers did not. He was within the normal speed range for going to a gun run. So, let's see here. The conclusion was that he was within policy 5.01, and we agree with the findings of the IG. Our motion is that we accept their findings on case number, sorry, I just lost my case number, 0097.
Is there a second? There's a second. All in favor? Motion passes.
Okay. The next one is 2022-0098. This one was excessive use of force. The allegation is that this individual was slammed against the car while being handcuffed, causing a chipped tooth and bruising. Complainant indicates that she was pulled over for no license tag on the vehicle. It took 3 officers to effect the arrest. She ended up being charged with falsification, no-op, and she alleges that she chipped her tooth, and that also she alleges that the officers refused to loosen her handcuffs. In this particular case, the IG went through all of the BWC cameras. They looked at video footage from the cruiser. They read the CAD reports. They read the arrest report. They came up with a finding of exonerated. And the footage indicates that the two officers who were there asked her for her driver's license, which she said she did not have. And then she, let's see, they asked for her name. She gave an alias, and then when they attempted to put her, or eventually, since she gave all false information as far as her birth date, name, she was going to be arrested, and she started cussing at the officers, etc., fighting with them, and all of this was on the body camera. And eventually, she asked that she be that the handcuffs be loosened, which the officer did, and this was also seen on the camera. Okay. Thank you. And she mentioned nothing about her tooth being chipped, and nor did she seek dental assistance. She did send some photos, but they were unable to, the IG was unable to identify her as the subject in the photos. So everything was done. We do agree with the finding of the IG. We move that the findings of the IG be accepted in case number 2022-0098.
Second.
Second.
And the final case,
Just a minute.
Got to vote.
To vote. All in favor of the motion, please raise your hand. Thank you. Motion passes.
Okay. 2022-0163, type misconduct. CPD officer used profanity. This was an administrative closure. Mr. Osborne stated that the CPD officer used profanity when dealing with him. When questioned, he said he did not want to proceed. He was mailed a withdrawal letter. He did not mail that letter back within the specified time limit. So the finding was administrative closure. We agree with the IG. We move to accept the findings of the IG on case number 2022-0163.
All in favor of the motion? Motion passes. I do need to look back to the IG on cases 0041 and 0045. Those were, in fact, investigative reports that came to us, those numbers. Okay, I'll have to figure where they are. And I have been told that from Team 1, Pastor Nathan, that case 0066 has been found, and we can actually move forward on that one. So let's do that one now.
I can do that one. So when I look back in the email, in case it helps anyone else, any other teams find cases they're missing, the first batch, the numbers saved on the documents themselves do not match up with the case numbers. So if you're searching for your email, just know that there might be some disparities with the cases. So our 2000-220066 was an allegation of misconduct during a traffic stop. However, the case was administratively closed because it was Ohio State Patrolman, not a Columbus Department of Police officer. And so that's, I don't know that there's anything to disagree about, but I would move that we would accept the report and recommendation of the IG on case number 2022-0066.
Second.
Second. All in favor indicate by saying aye. Motion passes. And, yes, I'm sorry.
You know, I was listening, and actually, I apologize, it just came to my head. Probably the disparity in the cases, and as going forward, we can make sure we note that, is when we close the case and it's generated as a board review case, it's given a different number. That's probably what the confusion is. We have one case number for our cases, and then the board gets a different case. So we can make sure that as we close the case, we're probably going to have to go back in there and either generate or add something to the report that will have the board's review number on there. That's what the disparity is on the cases, so we'll figure that out.
Chair Jackson, and that is a matrix thing.
Yes,
You
matrix.
click a button, they develop a new number. I saw you looking confused. I just want to make sure you know.
It wasn't confused. It was
know.
probably something else.
I know.
Okay, but thank you.
Right.
Thank you.
I'm up.
You're up.
Here we go. DIG complaint number 22-0013. The complainant alleges that CPD officers neglected to search a patient's belonging. This patient was taken to OSU Hospital. The complainant believed that the discovery of a BB gun suggested that CPD police officers either neglected to search the belongings or at least didn't thoroughly search his belongings. After a review of BWC footage, CPD policy and procedure, it is concluded that the allegation against both officers is exonerated, as no CPD policy, procedure, and/or law was violated. So, that being said, I move, or I motion move, to accept the IG's findings of exonerated in case number 22-0013.
Yes.
May I ask a question?
Yeah.
If someone is admitted, what kind of unit was this person admitted to in the hospital that they were concerned about searching his belongings? Was it an ER or a psychiatric hold?
Let's see, I'll tell you what, I'll read it to you. How about on July 13th, 2022, the complainant filed a complaint with the DIG alleging misconduct by Columbus police officers. The complainant, who is the Assistant Director of Medical Security at the OSU Hospital, alleged CPD officers transported an individual to OSU Hospital and they didn't search the individual's belongings. They found I think it was an airsoft BB gun, who they felt like the officer should have impounded that. But it's
Yeah,
not considered a firearm, so they don't.
I see.
Now, also, just let me say this. The IG also recommended that CPD policies be updated to ensure the appropriate response is clearly outlined so future instances like this do not occur.
So they're recommending a change in policy?
Update.
What does that mean?
That's a
So,
nice way of saying change.
so since there's no policy stating that officers should have removed the airsoft BB gun from the individual's belonging, the DIG concluded that no misconduct occurred.
I get
Because
that.
yeah.
But, well, I mean, that's what I was going to suggest, that this doesn't seem like a reasonable policy. You know, hospitals have become really dangerous places, and when you're conducting a search and you see something there, like some kind of BB gun or air gun, I was just going to say, you know, that it would seem like we would recommend that there be a change in policy, that there be a search and that kind of thing be confiscated until the person is released. So,
There's a question over here.
Mac, I'm sorry, I didn't quite hear you when you were talking about the allegation. Was the allegation that the search was not conducted, or was the allegation that the search was conducted, a BB gun was found and was left in the possession of the individual?
That he was not searched.
He was not
He was not
searched,
searched thoroughly.
but he was transported to the hospital.
Correct.
Now,
When in fact he was, and they didn't take the BB gun away from him simply because it's not a firearm.
okay. So the search did happen.
Yes, search did happen.
and so that's why I was suggesting that there be you know, I don't know if your updated policy means a change of policy, but that, yes, you know, that.
Yep. And, yep, and they agreed. Or they suggested that. That was their suggestion.
So for the motion, in addition to moving to approve the recommendation of the IG, there should be some consideration given to whether there should also be in that motion forwarding a recommendation to the chief of police to examine the policy in its current form to determine whether a change is appropriate or necessary to include airsoft, BB gun, or the like.
What he said.
And I'm also thinking, you know, and this goes back to the rule number 8, I'm not sure, but wouldn't it be just common sense if you found the BB gun to just tell the doctors or whomever is at the hospital, hey, we conducted a search and identified a BB gun on this person, just to let you know what you got coming in? Because if I remember correctly, wasn't there an incident that happened at Grant Hospital in
yes.
which a search was not conducted thoroughly and a weapon was identified on a person?
Yeah.
Well, we've had people murdered or killed for pointing cap guns and stuff, you know, so, you know, in this situation, you know, like what you said, Pastor Nathan, you know, people in the hospital, you know, if they were to see something like that, they wouldn't know what, there'd be a stampede up in there. Or a BB gun can do damage if you know what you're doing. A BB gun can become a serious weapon.
So do we need to have the motion amended?
I don't know if it was even seconded, because there were some questions. It was not.
There wasn't a
seconded,
second?
so-
Oh,
No, we had
so
discussion.
we can go back to have the motion restated?
That's up to the committee whether they want to make that recommendation to forward to the chief of police. If that's the consensus of the group, then yes, you can just amend the motion.
Well, there's a committee of one member for this particular reviewing committee, so.
I mean, without going and saying all that, I think it's already been taken care of. I think the IG is recommending that CPD does whatever we're asking.
But I still think it's a violation of policy when you talk about common sense and the
see-
work rule number 8.
And I'm with you. But what I'm trying to stick exactly to the complaint. So as far as the complaint goes, good. But outside of that, that's why they're recommending.
Is work rule number 8 cited in the IG's report?
Let's see here. No. They got CPD SOPs, division directives, transporting and slating, division directive 3.05, interaction with persons in mental crisis.
So it wasn't mental health, that's what I was asking before. Chair Jackson, one of the things that we were suggesting during our presentations was that we not confine ourselves to the complainant's definition of what policy was violated, because the complainant often doesn't know the scope of city rules or police policies. And so the fact that the complainant didn't say that this was a violation of a particular rule or doesn't mean that we can't find that this was was unreasonable conduct.
Right. I'm agreeing with you.
Oh,
I'm
but
agreeing
then
with
there wouldn't be an exoneration.
I do believe, though, if I may say, what we're trying to say, Willard, is that, yeah, we agree with what the IG recommended.
Yes.
But I think that what we're trying to say is we need to follow up with the IG in making that recommendation as a board.
Not quite.
No, I don't
Well,
think that's
I'm
what's
just
being
so
said.
so in other words, we're just saying just what she said then,
Well,
if
no.
we're not saying that.
I think what we're saying here is that there was another policy that should have been considered during the investigation, which is work rule number 8, that speaks
But we didn't
to,
start out saying that.
I know I'm saying that.
Okay, we didn't start out saying that.
I was saying that, but
I know.
I'm clarifying it a little bit
Okay,
more.
I'm with you on
But
that.
when the officer conducted the search, however, I think did not do due diligence in either informing the hospital personnel that they did see or find a BB gun in the commission of conducting that search. I think that was of, yes, work rule 8, because that policy speaks to common sense.
So would the motion in this particular case be then to refer this matter back to the Inspector General?
Yes.
Well, is it though? Because I think Mr. Tobias said earlier, we don't have to do that. We can just simply say, we think that this didn't comport with Rule 8, so our recommendation is not exonerated, but sustained along with the recommendation for an updated policy review. Is that right?
To
Yes.
send it back to the IG, the IG's already recommended some training or policy review, some policy review. You can decide whatever you want to recommend to the chief of police. So the recommendation can be a policy review in conjunction with Rule 8. If you want to mention Rule 8, you don't have to mention Rule 8. That's up to you as to what the nature of the recommendation is going to be to the chief of police in terms of what you would like her to review in relation to the incident, even though the officer was exonerated under current policy.
Okay, so whoever is the best at summarizing that in the motion, I think it'll be Brooke.
That's why I was passing that off, because
Well, it has to be a board member.
I can make a motion.
Please do.
So following review of case number 2022-0013, we recommend that the IG's finding of exonerated as to current rule be accepted, but that a recommendation be made to the chief of police to review the current policy to see whether a change needs to be made to require removal of items such as a BB gun upon a search.
Is a second? Any further discussion?
The discussion is that I don't think that the officer's actions were reasonable. And so I agree with Dr. Jones that this was a violation of the Work Rule 8, and that current policy covers this, that there should have been some communication to hospital personnel. This person has a BB gun. They either didn't do a thorough search, or they searched and said this was fine. We don't have to confiscate this because we don't consider this dangerous.
Yes.
And just as a suggestion, you all don't have to take it common sense is going to always be a subjective thing that you have
The
to kind
reasonable
of
man standard.
balance, Pastor Nathan. And I do think Rule 8 gives a few guidelines about what would be considered behaving with a lack of common sense or lack of common courtesy and professionalism under Rule 8 that could give the board some guidance about what was intended to be prohibited under that work rule.
You just want to make sure you're applying it consistently
Right.
across cases.
Right, exactly.
And to Pastor Nathan's point, you could still take a vote on the motion. A vote on the motion, it only requires 4 votes to pass. So all the votes have
So
been
there
unanimous.
is, in fact, a motion on the floor. There may be a disagreement from a board member as to whether or not it is the appropriate motion, but I'm going to call for a vote on the motion. So all in favor of the motion that was
And
made by,
I haven't asked the board to do a roll call vote yet because everything's been unanimous. But if it's going to be a split vote, perhaps a roll call vote would be appropriate so
Okay.
Bethany can get down who votes for and who votes against the motion.
okay, I'll take the. I'm sorry. It probably isn't appropriate for the chair to be seen laughing that way on camera.
I believe we're within what, Robert's Rules of Order if I amend the motion?
Okay.
All right.
Emotion?
We've been here since 2. It's long. My brain is starting to get fried. All right. So I move that we accept the finding of the IG on case number 0013 as it pertains to the existing allegation and finding. However, I also move that we render a finding of substantiated as it pertains to Work Rule 8 as well.
So I think I would need a second. I would need a vote on that one, but there's still the issue that there's an outstanding motion unless you withdraw your motion.
Well, I think she amended my motion.
Okay.
She was amending the motion that I put out on the floor.
Okay. There was a second to the amended motion?
Yes,
Yes.
as long as it included the recommendation that there be a review of the policy.
Yes.
And I second.
Okay, we got it.
I'm only looking at our wonderful executive assistant, who does a great job of keeping our minutes. On this one, she might have some challenges, but I will call for the vote on the amended motion. All in favor? Okay, passed. Oh, you,
It was unanimous, so you're good.
oh. We'll decipher.
No, I know what was said now, but I'm just saying there was so many different versions. I'm just trying to keep track of them.
Reach.
No, you're
You
fine,
wanna
Dr.
summarize?
Jones.
Oh, yeah,
You're fine.
you sure you got it? Because
Yeah.
we just agreed with the IG and we also included the
I
violation of
understand
Work
that.
Rule 8 and the review policy.
I'm with you.
Check, check, check.
Yes, ma'am.
Board, we only have 25 minutes left in this board meeting.
Okay.
And I would, it may not be possible, but I would like for us to finish the November cases if we can. So I go back to Board Member McIntosh.
Case number 22-0014, the allegation, the complainant stated she was involved in a vehicular collision. CPD officer responded to the scene, but did not complete an accident report. However, when she contacted the Columbus DIG, she stated that she obtained a copy of her accident report and did not wish to pursue the complaint she filed. So, I move to accept the DIG's findings of being administratively closed.
Second.
Oh, case number 22-0014.
All in favor? Motion passes. Next case.
All right. Case number 22-0015. 0-0016. Allegations. The complainant alleged Columbus police officers took his property, car, and apartment keys. Specifically, the complainant said that his keys were taken by Columbus police officers when his girlfriend was transported to a mental health facility. The complainant claims he told the officers they had the wrong keys, but the officers disregarded his statement. The conclusion. The complainant requested that his complaint alleging officer misconduct be withdrawn because he no longer believed the officer intentionally disregarded his statement about the officer taking the wrong keys. Therefore, it's recommended that the complaint be withdrawn. I move to accept the IG's findings of the complaint being withdrawn on case number 22-0016.
All in favor? Next case.
22-0014. Excuse me?
You did 1-4 already.
I'm sorry, 22-0048. Good. Let's see, two allegations. The complainant alleged that CPD officers did not take her concerns seriously or enforce the protection order. Number two, the complainant alleged that the sergeant who arrived on the scene after the officers was the primary individual who was rude and unwilling to help enforce the protection order. So let me just read through the summary. On July 22nd, 22, the complainant, Renee Marshall, filed a complaint, City of Columbus, Department of the IG, alleging misconduct by Police Sergeant Chris Bova, Officer Stephen Murphy, and Officer Matthew Bonner. The complainant alleged that the sergeant and officers were rude and unwilling to enforce a protection order. Based on the information and evidence obtained and reviewed, the Columbus DIG concluded that Sergeant Bova and Officers Murphy and Bonner's responses and demeanor regarding the incident were appropriate and supported by Columbus Division of Police policies, procedures, past practices, and/or laws. Based on the information and evidence obtained and reviewed, the Columbus DIG concluded that Sergeant Bova and Officers Murphy and Bonner's responses and demeanors regarding the incident were appropriate and supported by CPD policies, procedures, past practices, and/or laws. Therefore, it is recommended that the allegations against Sergeant Bova and Officers Murphy and Bonner are unfounded. And we all agreed in our committee with the IG's findings, and I move to accept the IG's findings of unfounded. Oh, I'm sorry, case number 22-0048.
Second. All in favor? Motion passes.
Complaint number 22-0049. The allegation, the complainant alleges that a Columbus Division of Police cruiser with no emergency lights or sirens activated merged in front of his tractor trailer on the interstate. When the complainant honked at the cruiser, the officer proceeded to unnecessarily slam on the brakes, essentially brake checking the tractor trailer.
They didn't hit him.
No, no. Let's see.
camera footage?
Yes, there was camera footage. The investigator reviewed the video footage provided by senior management of security at ABF Freight. The video supported the complainant's statement. The video taken from the front of the involved tractor trailer shows a CPD cruiser with license plate number 82 merging, excuse me, in its way into the tractor trailer's lane with no blinker. While merging, the cruiser can be seen going across the yellow line and almost completely onto the left shoulder. The video then shows the cruiser coming to a complete stop in front of the tractor trailer on the interstate with no traffic in front of the cruiser. The tractor trailer can be seen getting very close to the rear of the cruiser before coming to a complete stop as well. The cruiser then proceeds to move to I-70. So, the findings, based on the information and evidence obtained and reviewed, the Columbus DIG concluded that Officer Stevens' actions violated CPD policy, procedure, and/or laws, specifically CPD Directive 1-01. So therefore, the DIG recommends that the allegation against Officer Stevens is sustained. And I move to accept the DIG's recommendation of sustained in case number 22-0049.
Was there a recommendation for discipline in that finding?
Let me see here. It is also recommended that the investigation report be forwarded to the City of Columbus, Director of Public Safety and/or Chief of Police for review and consideration of disciplinary action in accordance with CPD policies and procedures.
Did we vote on? Okay. There was a question. Question has been answered. All in favor of the motion? Motion passes.
Case number 22-0052. Allegations. The complainant alleged that CPD officers failed to properly handle and respond to his calls for service regarding a party in his neighborhood. On July 25th, 2022, the complainant, Harvey Graff, filed a complaint with the City of Columbus alleging misconduct by police officers Greg Lindsay and Joseph Rebar and Jared Schaefer. The complainant alleged that the previously mentioned CPD officers did not appropriately handle his calls for service regarding a party in his neighborhood. After a review of all relevant evidence and documents, it is recommended that the allegation for Officer Lindsay and Officer Rebar is exonerated, and the allegation for Officer Schaefer is sustained. Officer Lindsay and Officer Rebar's actions were supported by CPD policies, procedures, and/or laws. However, Officer Schaefer's actions violated CPD's policies and/or laws. And I think what Officer Lindsay did, Officer Schaefer, I might have to read it to you. Here's the analysis and findings. The complainant, Mr. Graff, was interviewed regarding this allegation. The complainant informed the Columbus DIG that he called non-emergency services on July 23rd, 2022 to report an illegal gathering in his neighborhood that contained illegal structures and loud music. Per the complainant, the responding officers for his call did not stop at the incident location nor make contact with him regarding his complaint. The complainant reported that he then called non-emergency services again a few hours later, asking for officers to respond to the location again, and there was still loud music and structures on the property. The complainant requested that the officers who responded this time speak with him either before or after making contact with the individuals at the incident location. The complainant reported that the officers did not contact him after the second call for service, and that he was unaware if they even responded to the incident location. A review of the 911 audio recordings and accompanying CAD printouts supported the complainant's statements regarding him making calls for service. Through the CAD reports, it was able to determine that the officers Lindsay and Rebar responded to the first call for service, and that Officer Schaefer responded to the second call for service. Per the CAD report, the first call of service was entered in a 1016, which is a code for a disturbance. BWC footage obtained for Officer Rebar revealed that the incident was appropriately handled as outlined in Columbus Police Patrol Subdivision 2.02. Per SOP .202, 2.02, officers should take enforcement action as needed, and there was no requirement to make contact with the caller when responding to a disturbance. The BWC footage showed Officer Rebar speaking with individuals at the incident location and advising them that their structures in question, a pop-up tent and table, are in fact legal, as pop-up tents and tables are not listed as prohibited items under Columbus Ordinance 3332-289. In BWC footage, Officer Rebar can be seen moving his camera off his chest to better show these structures, ensuring his documentation was thorough. The BWC footage also showed Officer Rebar contacting dispatch to determine whether or not the complainant needed a report made. The detective advises him that there is only a note that states that the complainant can be contacted if needed. Based on this information, it is concluded that officers did stop at the incident location, did make contact with the individuals at the location, did properly address the incident, and did confirm that contact with the complainant was not requested. Therefore, Officer Rebar and Officer Lindy's allegation is exonerated, as they responded and investigated the first call for service in compliance with CPD policy and procedure. Officer Schaefer, on the other hand, he responded to the second call, can be seen approaching the listed address, speaking with present individuals, asking them to turn down the music. Due to the video ending as Officer Schaefer was getting back in his cruiser, this investigator was unable to determine if Schaefer attempted to make contact with the complainant, as outlined in Columbus Police Patrol Subdivision SOP 2.02, which says officers are to contact the caller if known, unless information indicates the caller does not wish to be contacted. So, again, it is recommended that allegations against Officer Rebar and Lindsay be closed with a finding of exonerated. And as it also relates to this incident, the Officer Schaefer's response violated CPD's policies and procedures. It is recommended that the allegations against Officer Schaefer be closed with a finding of sustained. So I moved to accept the DIG's findings of exonerated for Officers Rebar and Lindsay, and I also move for us to accept the findings of the DIG's allegations against Officer Schaefer to be closed, the finding of sustained in case number 22-0052.
Questions? All in favor? Motion passes.
Case number 22-0057. Allegation 1. The complainant alleges that CPD officers failed to properly handle his call for service. The complainant also alleges officers cracked jokes with the suspect rather than arresting him. Summary is, on July 25th, 2022, the complainant, Terrence Jones, filed a complaint with the DIG alleging misconduct by police officers Austin Covey, Samuel Moore, and Linda Gutierrez. The complainant alleged that CPD officers did not appropriately handle his call for service regarding his nephew threatening him with a firearm. The complainant alleged that officers laughed and cracked jokes rather than arresting his nephew. The complainant felt the officers' actions showed that they did not take his complaint seriously, which allowed his nephew to think his behavior was acceptable. A review of the BWC footage for the involved officers and CPD policies and procedures revealed the officers' actions were supported by CPD policies, procedures, and/or laws. Therefore, it is recommended that the allegations against the officers be exonerated. So,
I think there's been a motion.
I motion that we accept the DIG's findings of exonerated.
Just a quick question.
Yes.
Did they review
And huh?
Did they review the body?
Yes.
Is that what they did?
Yes.
Okay. Thank you.
To accept the IG's findings of exonerated against the officers in case number 22-0057.
My bad, y'all, my bad.
All in favor of the motion? Motion passes.
All right. 22-0105. Type of complaint, misconduct, operation of vehicle, unbecoming conduct, rude or discourteous behavior. Allegation 1, the officers in the cruiser were speeding. Allegation number 2, the officers were high on drugs and slurring their words. And allegation number 3, the officers were harassing her and combative. Allegation number 4, the officer threw her ticket in her car window. August 4th, 2022, City of Columbus Department of DIG opened an investigation to allegation of misconduct involving a Columbus police officer. The complainant, Tracy Kane, alleged that a Columbus police officer cruiser was speeding on Petsinger Road at 60 miles per hour and pulled her over. The complainant stated that the officers looked like they were high, had been drinking, slurred their words, and got aggressive and combative. The complainant further added that the ticket was thrown in her window. The officers left the scene speeding off. The complainant stated she called 911 several times asking for a supervisor to respond to her location, and none was ever dispatched. Tracy stated that her daughter began video recording the officers' actions because she became scared. The investigator reviewed Cruiser 94's speed data prior to the stop, which indicated that the maximum speed of Cruiser 94 was 46 miles per hour, which is 21 miles over the posted speed limit of 25. The patrol SOP listed disturbance 1016 runs as a priority 3, which is not a run where an officer should respond without delay. So while the cruiser did not reach the speed that was initially alleged by the complainant, the officers did exceed the posted speed limit. Therefore, the DIG recommends allegation 1 be sustained. The investigator reviewed the BWC footage and phone camera footage provided by the complainant and observed no indications of the complainant's allegations that the officers were drunk, high, or slurring their words. Additional BWC footage of the officers were reviewed after the traffic stop, and there were still no indications of alcohol or drug usage. Therefore, DIG recommends allegation 2 be unfounded. The investigator reviewed BWC footage and phone camera footage provided by the complainant and observed some questioning by Officer Jeremy Spoonmore regarding the complainants being a parent of the children. If there were guns or weapons in the vehicle, why she didn't stop at the stop sign, and other questions that were investigative in nature. Therefore, to the allegation of the officers being harassing and combative in their questioning of the complainant, the DIG recommends this portion of allegation 3 be exonerated. The investigator reviewed BWC footage of Officer Christopher Choi's action to handle the driver's license and ticket copy into the opening of the window to return her documents. The complainant reached her hand up and was handed these documents from Officer Choi's hands to hers. They were not thrown in the car window. Therefore, the DIG recommends allegation be unfounded. I move to accept the allegations of the DIG, allegation 1, the findings of DIG, and allegations 1 to be exonerated, 2 to be unfounded, 1 to be sustained, 2 to be unfounded, 3 to be exonerated, and 4 to be unfounded in case number 22-0105.
Second.
All in favor? Motion passes. We're going to stop at this point in terms of the review of these cases, because I want us, so I'm not sure if this means we'll need to have 2 meetings in February in terms of time. But I really do think it's important for us to kind of, I'll say debrief, right now in terms of how we can make this a smoother process. I would say a shorter process, working towards a template, but I would really love for us to have input, not only from members of the board, but I'd be more than willing to accept recommendations from council or the IG, but and as I say that, this was our first time. It was a heavy, heavy lift. I think that the work done was exceptional, but we need to constantly be improving. And so with that said, are there any comments from board members or others as to recommendations that you might make before that we could actually make recommendations and incorporate them before our next meeting?
My thought is this. Certainly, I agree with being more efficient and perhaps doing it in a quicker manner. However, just like on that first one that I did, I thought that was going to be very quick, lickety-split. And then there were questions. So then you have to go back and kind of read it. Because
So that's why you
sometimes
switch to sharing.
Yeah,
everything.
exactly. So I said, well, let me just do instead of trying to do it in the short way.
One of the things that might be helpful, and this is coming from someone who has not been involved in this, really in the process, again, literally is around how you organize your materials. I am one who believes in the composition notebook. And so literally, it could be, or you could be using your computer, however you want to do it. But for each case, outlining specifically the important things that you need to hit so that you're not constantly kind of going back, back and forth. Have your materials with you. Highlight the most important. So if you must go back, you might want to have your review sheet actually attached to the IG's report. I would suggest that when you get the agenda and they're listed, that you have them in a stack where you're following the agenda in terms of the number, to keep yourself sort of on track. I am certainly very interested in this idea of a template. I'd like to hear more about that. And I put you on the spot. Are you willing to work on this?
Yeah, so me and Attorney Ross were actually talking about this during the break. And so I think we all agree that a template will help streamline this process of reporting out. And I think we don't necessarily need to reinvent the wheel. I think we can actually build it into the worksheet, just adding a couple of areas that may offer a summary of the actual case, where they can probably just copy and paste what was in the IG's report right there, and then they can just use that worksheet that has the case number, the allegations, the summary, what it already has, what type of footage was reviewed, and then the outcome, and then notes in terms of whether or not we agree or disagree with that, and recommendations for moving forward. So I think I can get that done within the next few days.
And let me, now this is from someone I don't have to complete these reports. And I acknowledge that my technology skills are woeful. So although you said something so easily in terms of cutting and pasting, I don't know if that skill set resides with all three chairs or committees. We may have to, think of something else. That's all I'm.
It would say summary. So I mean, if the document is able to print it off and write into it as well. So, if they can't copy and paste it, then they'll be able to write or draft a little summary. Yeah, to make it.
The summary that Dr. Jones is speaking of is already typed and drafted in the IG's report. And so if it's just a matter of reading directly off of the report what the summary is, to my knowledge, it's never going to be more than about a paragraph for each case, unless the case is super robust and calls for more than a paragraph. So members of the board should not anticipate having to read a whole lot when reading the summary, but it does go over the high-level critical facts of what was investigated. And I would also suggest that a copy and paste or reading directly from the conclusion of the report is also going to give insight as to why a particular complaint was sustained and or exonerated or unfounded, that I think is going to be helpful to edify the board as well.
Other suggestions? And I know that there is a lot of paper, but it's incumbent, especially upon the chairs or those reporting out, that after your committee meets, you probably need to spend some time by yourself in terms of outlining how you're going to report it out. I can imagine that you're having very robust discussions when you meet, but to get it succinctly and in front of you, I think would be helpful. Anything else? Then we're going to, thank you very much. And thank you, Attorney Ross.
Attorney Tobias and I also will be working on an opinion with regard to Work Rule 8, because it does seem like Work Rule 8 by the board is being used as a little bit of a catch-all. We want to make sure that you guys have some specific language about what was intended to be used or considered as misconduct under that rule. There is some guidance in the exact text of the rule, but we also want to make sure that we have some policy just so that you're using it consistently across the board.
And is that something that could be distributed to the board prior to our next meeting, and especially as they may be meeting to consider these additional cases?
Try to move that
Yep, we'll
along.
move. Yeah, quick.
Okay.
I'll start it tonight.
So what I need from the board members today would for you to assemble, I'm assuming you have them with you, the investigative memorandums for your cases that you have. Do you have them? No? Yes? The
worksheets?
The worksheet, well, no, because when you actually look at the report that comes from the IG, and I think I can just go back and they can be reprinted, it's going to require, well, it should have a signature from the, I'm talking about this page. It should have a signature by the chair of the committee, and then I have to have it to sign off on it. So, do you have these documents with you? Right? Right? Would you please take the time to sign the ones that we have completed today? For November. And your chair is in here, so you could just put acting chair, Ms. Younger, and leave all of those with Bethany. And then I'm going to set an appointment so that I come to the office. I'll have to have your not necessarily the official minutes, but your notes from this before I can go through and actually sign and convey the ones that need to go to the chief. As you are doing that, and this is for the purposes of assignments, there are 16 cases to be assigned, and we're going to really double check on these after, today. I'm going to start with the committee chaired by Pastor Nathan. I will not read the first four numbers of 2022. These are the committee's case assignments. 0362, 0367. The next one actually has two numbers in one. 0368 and 0267 would be one investigation. 0369, 0379, and 0380. This committee actually has 6 investigations. To the committee chaired by member Kyle Strickland, the case numbers are 0389, 0390, 0405, 0408, and 0411. Committee chaired by member McIntosh, 0417, 0424, 0431, 0452, and 0475. I think it would probably be a wise thing for the board to be polled for a second meeting in February. We will certainly come into the first meeting in February with the hope that we could get all of the cases completed. But if we can't, then we would already have a meeting in place. And so expect correspondence on that to go out fairly quickly. Of the members who are here today, does keeping the meeting on a Tuesday at the same time work for you? I mean, just kind of as you look at your calendar, Tuesdays would probably be a better day? Okay, we'll start with that. Anything else to come before the board today?
Madam Chair.
Yes.
Going back again to what we were tasked to do with our individual subcommittee meetings,
Yes.
For us to make sure that we are in compliance, will there be a WebEx set up for us to be able to utilize so that those meetings are televised for those who may want to watch? Will there be some kind of a medium that we have access to, or our chairs have access to, that when we meet, we can make sure we're in compliance?
I hear what you're saying, and you mentioned WebEx, which is a city,
Well,
It's putting the cart before the horse. Nothing's been approved yet by city council, but I would imagine if they do authorize the virtual subcommittee meetings, then the city platform may become available to use for those meetings.
so in essence, then, the meetings that we will have before our next meeting, we don't have to worry about it.
That's right.
no, you're going to keep doing the same thing,
Okay.
just making sure that there's notice in a good place. When I come in for a meeting in the IG's office, so there was a motion made, but that motion needs to be reduced to writing out of our minutes and to be sent, a memorandum that I would assume is appropriate to go to President of Council Shannon Harden, coming from essentially me, about this. So we will work on that together when we actually meet.
I'll send those to you, Mary.
Is there anything else?
Willard, because him having to be a committee of one, I know was not real easy, not having some input from some of his other.
Now, he had, in terms of his committee meetings, well, for this group, there were 3 members.
Okay,
I mean, and then for the group that was assigned in December, he would have had member Fluharty
Okay,
with him.
very good.
He's just missing from the meeting
okay.
today. Motion to adjourn.
So moved.
Second.
All in favor?
Aye.
We are adjourned. Please make sure that your signed documents, and of course, Matt, for you, it's only the ones that you presented today. Okay?
And only